Welcome everyone, good afternoon. Thank you for joining us for the Camp Lejeune Water Contamination webinar. I'm Haley Upton, Marketing Coordinator of Events and Proposals for Warden Smith. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I will try and troubleshoot with you. Our speaker today is happy to take questions during this webinar. If you have a question, please type it into the Q&A box and it will be addressed either during the presentation or at the conclusion of the presentation, just depending on the nature of the question. Allow me to introduce our speaker today, Lynwood Evans. Lynwood leads the Warden Smith litigation practice and is one of the attorneys involved in the Camp Lejeune water contamination litigation efforts. His experience encompasses a wide variety of civil litigation in both state and federal courts. He has extensive experience in all aspects of litigation, including depositions, hearings, mediations, as well as arbitrations, appeal, and cases tried to jury verdict. Lynwood, I'll go ahead and turn it over to you.
Thank you, Haley, and welcome everyone. We certainly appreciate you joining us today. Haley, do I have control of the slide deck now?
Yes.
One second.
Lynwood, we did lose your video.
That's exciting. All right. I'm not sure
Okay.
how that happened.
No problem.
Okay,
Oh, there you are.
we're back. All right, for some reason, I'm not able to control the slides. Can I just ask
No problem.
that for me, please?
Yep, absolutely.
You could just go to the cover slide. There we go. That'd be fine. So welcome, folks. Appreciate your patience while we work through a couple of technical glitches at the outset. As Haley indicated, I am one of the litigation lawyers here at Warden Smith. We are an Eastern North Carolina firm. We are a successor to a firm that began in the early 1800s. Our original Warden Smith office was in New Bern, North Carolina, and we now have offices in 5 North Carolina cities and towns, 4 of which are in Eastern North Carolina, Raleigh East. I was born and raised here in North Carolina, and more specifically in Eastern North Carolina. I went to undergraduate school and law school here in North Carolina, and then came to practice here in Greenville, North Carolina at the conclusion of law school. We've got several other members of our Camp Lejeune litigation team that I will briefly speak to before we dive into the substance of the rest of the presentation. One of our members is General Hugh Overholt. He was born in Arkansas and then lived really all over the world as his military career progressed. At the end of his military career, he was the Judge Advocate General for the United States Army. So he was the highest ranking lawyer in the Army at the conclusion of his service. After retiring from active duty, General Overholt went into the private practice of law and eventually made his way to our firm, where he has lived in Eastern North Carolina, more specifically in New Bern, for the last many decades of his career. Another member of our Camp Lejeune litigation team was born and raised right in the shadows of Camp Lejeune in Jacksonville, North Carolina. His father was a World War II veteran and was a founding member of the USO there in Jacksonville. In fact, the airport there in Jacksonville that for decades has flown Marines and their families in and out of the area is named for Mr. Ellis's father, the Albert J. Ellis Airport. Charles has been practicing more than 40 years, also attended undergraduate and law school here in North Carolina, and has tried over 100 jury trials to verdict. He's a key member of our litigation team here for Camp Lejeune. We also have another member of our team born and raised in Wilmington, North Carolina, also Eastern North Carolina, went on to law school and undergraduate school at UNC, where he graduated first in both his undergraduate and his law school class. Returned home to Wilmington. He works out of our Wilmington office, is excellent litigator, excellent trial lawyer. Another member of our team, Ms. Jenna Butler, has been practicing approximately 30 years, started her law career with a large firm in Atlanta before moving to Wilmington. She works out of our Wilmington office, a very skilled and tenacious litigator. In total, we have 8 litigators in our section who began or served a portion of their legal career in the federal court system as federal clerks. Every federal judge has at least one, usually 2 or 3, typically new lawyers who help them with legal issues that arise in the courtroom. And as I indicated, we've got 8 of those who began or spent a portion of their career in the federal court system. So with that, let me jump into specific information with regard to Camp Lejeune. Forever, it was called Camp Lejeune. More recently, some folks have begun to refer to it as Camp Lejeune. That's still difficult for me because for so long it was Camp Lejeune, and to many of you, it probably has been and still is Camp Lejeune, and so that's how I'll refer to it today. As by now I'm sure you're aware, the key period here with regard to the contaminated water at Camp Lejeune was from 1953 to 1987. It did involve the drinking water, although folks who lived on base did really everything that they needed water for with that same contaminated water. There are a number of dangerous chemicals that we'll talk about during the course of today that have now been conclusively found in that water system and a number of diseases that it has been known to cause. Haley, if you could go to the next slide for me, please. We're going to structure today by trying to hit some hot topics, some questions that we have been asked by clients and potential clients over time that we have incorporated into this presentation. However, we would like it to be very useful to you, and we want to ask or answer your specific questions. So if you do have those as they arise, if you'd like to drop them down in that Q&A section, it's at the bottom in the center of my screen. I'm not sure where it might appear on yours. Haley, I don't see any questions yet. Do you have any showing on your side?
No, sir, I do not. Well, actually, I apologize. Someone asked if this recording was going to be sent over at the conclusion, and it will be. We will send out a recording.
All righty. As others rise, you're welcome to bring those to our attention, and we'll be happy to answer them for you. So a little bit more detail about what happened at Camp Lejeune. As I indicated, there were a number of chemicals that caused contamination there in the water supply. And it impacted, obviously, the first thought is should and often does turn to service members themselves, those actually in the Marine Corps, but family members, civilian contractors, folks who had reason to work on base or were on base regularly were also impacted and potentially have claims under the Act. The the general term Camp Lejeune is really how most folks refer to the broader area, but there are many more specific areas within the base, such as New River Air Station. We'll show you a map a little later in the presentation and some of the other areas in base. You need not have lived on Camp Lejeune proper to have a potential claim, but we'll talk about that in more detail as we move forward. Next slide, please. So what is the Camp Lejeune Justice Act? This is a piece of legislation as part of a larger act called the PACT Act that was recently passed. A little bit of history. A decade or so ago, there were a number of plaintiffs who filed lawsuits after going through the administrative claim process in North Carolina seeking compensation for damages that they sustained as a result of the contaminated water. That litigation had a long, painful course that unfortunately ended with all of those claims either being denied at the administrative claim stage and or dismissed from court. The two primary reasons that litigation ended and ultimately failed was as to military members, a doctrine called the Ferries Doctrine, which says basically that the United States is immune or has immunity from any claims arising out of active duty service. The other main reason that those claims were dismissed from court and denied in the administrative stage was the timing. They were all filed outside of North Carolina's statute of repose. The statute of repose is really just a time limit within which claims must be filed. As a result of those claims being dismissed, a lawyer from South Carolina named Ed Bell began to try to find another way to allow folks who were injured by this water and or killed by the water to have valid claims. And so that's sort of where we came into the story. He was put in contact with General Overholt, and the two of them worked together with others in Washington to draft and navigate this act through the legislative process. It was long. It wasn't a straight line route. It was circuitous, as is often the case in the legislative process. There were fits and starts. There were changes in legislators. There was deaths of legislators who were involved in the process. But eventually, as you all have become aware now, the Camp Lejeune Justice Act was eventually attached to the larger Veterans Relief Act, the PACT Act, and passed. Next slide, Haley. Thank you so much. I mentioned the North Carolina law, the statute of repose, a little earlier. The language of the Camp Lejeune Justice Act essentially overrides, or the legal term preempts, North Carolina's statute of repose only as to these specific claims. And so even though some of these claims arose in the 50s and are now 70 years old, or nearly 70 years old, this legislation allows those folks to seek compensation. The act, although not indicated on the slide, also essentially renders the Ferries Doctrine or immunity for the United States with regard to injuries arising out of active duty service moot. That it does not apply to these specific claims. I see there's a question. Yeah, good question. I don't know if everybody can see it, but the question involves VA benefits and how the Camp Lejeune Justice Act interacts with those benefits. We're going to talk about that a little later in the presentation. It is an issue that many, if not most, are concerned about, and we'll certainly address it. If after we get through that section, your question hasn't been fully answered, please let us know, and we'll continue to address it. Next slide, please. All righty, so who can file a claim under the Justice Act? I've already indicated active duty service, their family, really anyone who was exposed for a period of greater than 30 days. So it could be family members, dependents, others who are living in the household. It could also be dependents, family members, spouses, children, even if they didn't live on base, if they were exposed to the water for more than 30 days on the base. Also, civilian contractors, those who worked on the base, even though they were not technically employed by the military, would also potentially have claims. And as this slide indicates, decedents of impacted people who have died also qualify for claims. I'll point out one other category of folks here too. A number of children were exposed to the water in utero. So while mother was pregnant, mother was on base, drank the water, used the water for more than 30 days. And those folks, even if they did not live on base, those babies who are now most likely adults, even if they did not live on base, if they were exposed in utero for more than 30 days, are potentially eligible for claims as well. Next slide, please. All righty, many of you are probably aware Camp Lejeune is located in eastern North Carolina. It's about an hour drive from our New Bern office, where I previously indicated the firm originated. About an hour drive from our Wilmington office, about a 90-minute drive from our Greenville office, where I'm now sitting, and about a 2-hour drive from our Raleigh office. Probably more significantly for purposes of this litigation is that the exclusive jurisdiction is the Eastern District of North Carolina and the federal court system. In that federal court system in Eastern North Carolina, there are 4 courthouses that have personnel in them on a daily basis. There are others that are not staffed but are sometimes used. But with regard to the staffed courthouses, they are located in Raleigh, where we have an office, Greenville, where we have an office, New Bern, where we have an office, and Wilmington, where we have an office. So long before these TV commercials started and the folks advertising to attempt to attract potential claimants, we were practicing in these very locations where these claims will be litigated. Next slide, please. As I indicated before, this is a map of the Camp Lejeune disability area. This is a map that's actually being used by the VA. Here's the New River Air Station on the map. There are other particular areas that are shown here, Had Not Point and the others. And so there's Camp Geiger up here toward the northwest. Actually, that's northeast, yeah, northwest. And so there's others as well. And they're usually, in talking with folks, what we find is, regardless of where your housing might have been, if you lived there, you were all over the base, training, working, exercises, and so there's a good chance that no matter where you lived on the base, you were probably exposed to the water, even if a particular well where you lived was not contaminated. So next slide, please.
Lynwood, sorry,
Sure.
just want to interrupt you because we have a question in regards to the map. Was Camp Johnson included? And I do see it on the map, so I'll let you answer this. Camp Johnson.
Yes. So it gets a little bit more detailed than probably we can handle in this presentation, but there are specific wells that had specific contaminants, and there's publicly available data that track sort of how that well water flowed through, or how the water from those individual contaminated wells flowed through the base at different times. The flow was not the same at all times based on which ones had higher volume and flow. And so it gets a bit complicated with regard to what contaminants were in which location at which time. But that is data that can be drilled down into if and when that becomes necessary. I think there was a second question as well. Yeah, we've already addressed that. So perfect. Next slide, please, Haley. Thank you so much. So a big question. There are some advertisements that are indicating a specific amount of compensation is available or will be available in these claims, and that is just not accurate. There have been no dollar figures set aside or attached to this legislation. Every piece of legislation does have a score that is part of the legislative process, but that is a completely different and separate issue from how much an individual claim is worth. There are positives and negative, pros and cons to there not being a specific settlement pool available. If there's a defined amount, by way of example, everyone will recall the 9/11 tragedy. There was a specific dollar amount set aside. And then in terms of how individual claimants were compensated, that pool was then divided, but it was a known sum or quantity. That does not exist here. Ultimately, these claims under the legislation, their value will be determined by juries in these courthouses that I've described here. There is an administrative process that takes 6 months that must occur before a lawsuit is filed and before the sort of litigation process ensues. It is certainly possible, though probably unlikely, that the government may offer to settle claims during that administrative process. If that occurs, it is most likely that it will occur with some sort of dollar amount, consistent dollar amount that is really not based on the value of individual claims. The reason I say that is because the number of claimants that there are, it is estimated that over 1 million people were exposed to the water during this applicable period. The court systems have, there has been numbers batted around about numbers of anticipated suits. 30, 40, 50,000 have, those numbers have been discussed, but it could be significantly more. The other issue is that the system within which to handle these claims just doesn't currently exist. The government is having trouble at present even accepting the volume of one-page administrative claim forms that are required to start the process. They have indicated that there is no plan to currently accept even medical records as part of that claims process because of the volume, the sheer volume and storage of those and processing of those. And so while that may eventually occur down the road, and it will have to occur if those materials are going to be used to individually value claims, there isn't a current process for the government to accept those medical records. And so that's why I say it is unlikely that there will be claim-specific offers to settle. In other words, offers to settle in the administrative claim period that relate to how the water impacted the individual claimant. So ultimately, our plan as a litigation team, we are litigating these cases with the Bell Law Firm, is to work them up and prepare the medicine and the science to be among the group of lawyers that try the cases. And it is likely that a number of cases in individual disease categories will have to be tried at some point in this process to start to get a feel for value. That said, practically speaking, that volume of cases probably will not be tried to jury. In other words, everyone tried to jury, just given resources. And so it is likely that after a certain number, and nobody knows how many, cases are tried and values are set by juries, that eventually some matrix or framework is worked out or proposed to offer settlements to folks who were injured. Next slide, please. All righty, so where did the contamination come from? Terroir Terrace has a treatment plant. There's also a housing area there. You got Hadnot Point, which is also a housing area, and there was a treatment plant there. There was also separate wells that fed into these treatment plants. It appears that the contamination was, in certain instances, isolated. In other words, primarily from one well area, or the well was put into an area that had been contaminated. But in any event, there was a report that was published by the government, the ATSBR report. There's a link to that on our website if you would like to go there and read the report in detail. That report talks about these volatile organic compounds, or VOCs, that seeped into the areas around the wells, and then the wells to the treatment plants, and then ultimately to the individuals who drank it, who bathed in it, cooked with it, swam in it, in the swimming pools, etc. Next slide, please. So this slide talks a little bit more about the specific chemicals, the PERC, the TCE, vinyl chloride, benzene. We've got another slide for each of these. If we could look at that. The PERCs are industrial solvents, most commonly used in dry cleaning fabrics. There was a large dry cleaner that was off base but adjacent to base, and it is believed that a lot of the PERC, maybe all of it, came from the off base site but contaminated the area where a well on base was located, that was then transported to the water treatment facilities and then out to the base housing and work areas, etc. Next slide. We've got the TCE. That's a chemical solvent, a degreaser used with metal machinery. Obviously, there is just a tremendous amount of machinery used at Camp Lejeune, both then and now. And chemicals used as part of servicing those were then drained and taken out and dumped, disposed of, unfortunately, in a manner that ended up seeping into the water system. Wells were tapped into it and again took them to the water treatment plant and ultimately to the servicemen. Each chemical you'll see here are linked to specific injuries. Some injuries or diseases are linked to multiple chemicals, but as you see here, TCE has been linked to liver and kidney issues. Vinyl chloride is another. This is an important chemical used in PVC pipe production. It's tied to various cancers, central nervous system issues, and other matters. Haley, thank you. Benzene is another one of the chemicals found on base in the water system. Has to do with manufacturing of plastics and other synthetic materials. Long-term exposure to benzene has been linked to bone marrow issues, red blood cell issues, and red blood cells are produced in the bone marrow, immune system issues, reproductive problems, and fetal development issues. Next slide, please. So what sorts of diseases and problems have been linked to these various chemicals? Again, it's too detailed to get into today to link specific chemicals with specific diseases, but we'll provide a list on this next slide of diseases. Obviously, one of the main concerns is cancer. There's a long list of various cancers that are linked to these chemicals in the water system, from bladder to brain, breast, cervical, esophageal, kidney, leukemia. The list goes on. Next slide. A number of other non-cancer or conditions that folks might not consider or relate to cancer: bone marrow conditions, aplastic anemia, cardiac defects, renal disease separate and apart from kidney cancer, eye defects, Hodgkin's disease, non-Hodgkin's lymphoma as well is on the list here. Neurologic effects, Parkinson's disease is a large one. Renal toxicity, again, kidney issues, sclerodermas, various skin disorders. Next slide, please. We've got here a list of other possible conditions: female infertility, stillbirths. Tragically, there are multiple cemeteries dedicated to stillborn babies from Camp Lejeune that are right off base. Gallbladder cancers, hepatic stenosis, intestinal cancer, spinal cancer, soft tissue sarcoma. You see the rest of the list there. Talk a moment about the ASTDR. Within that document, the government has agreed that certain classes of diseases have a certain relationship to these chemicals. Many folks have sort of referred to them as three categories or three classes of diseases. The first is a presumptive relationship, meaning the government has, or the ASTR, which is the government study, indicated that diseases in that category are presumed. There is a presumption that they were caused by one or more of those chemicals that are known to be in the water. There's a second category of diseases that the government study indicates are as likely as not. A standard called equipoise, as likely as not. And so that's a second list or second class of disorders that are as likely as not caused. The burden of proof contained in the Justice Act. So a person making a claim has to prove their claim to at least the as likely as not standard. And so the standard in the Act tracks the standard in the ATS-DR that says the as likely as not diseases hopefully will be compensated. And then everything else sort of falls in this third category. The ASTR does reference a number of diseases in this third category as having at least one study that has established a link to one or more of the contaminants in the water. The hope is that over time, more diseases in that third category will able to be linked to one or more of the contaminants to that as likely as not standard. You will see that some lawyers are only accepting claims in category 1. Some are accepting only claims in category 1 or 2. And some are accepting claims in 1, 2, and 3. We fall in that last category. We are accepting claims in all three of those categories. Next slide, please. All right, so what kind of documents would it be helpful to obtain and to start to begin to collect and put in a safe place so that at the appropriate time when they are needed, they will be available? So documents that prove you spent time at Camp Lejeune. I have seen equipment inventories that were issued from Camp Lejeune to individuals. Obviously, military service records. The DD 214 is the most obvious. If you end up, many folks on the call or on the webinar today may already be clients of the firm. We can provide you resources, websites, addresses, phone numbers to obtain those military records if you do not already have them. Second, medical records, medical bills, receipts. Obviously, we're not going to be able to have perfect information in that regard. Many of the records from the 50s, 60s, maybe even the 70s are probably not going to be able to be found. But we'll do the best that we can. We ask that you do the best that you can to create a list of treatment providers related to the diseases or disorders that you believe were caused by the water, such that those records can be rounded up. Veterans Administration documents are important. One of the reasons they're important is the question that was asked earlier that we'll address in a moment, and that has to do with the credit or the offset for VA benefits that have been paid related to diseases or problems caused by the Camp Lejeune water. Same goes for the last category there on the slide, information of prior benefit claims and disability compensation. Also, as part of qualifying for VA benefits related to these diseases or disorders, many veterans have received correspondence, letters, etc., acknowledging the link between their individual disease and the water at Camp Lejeune. And so obviously we would like to get copies of those if you have them. Next slide, please. So looking a bit at damages, while a specific dollar amount is not known with regard to how much an individual claim is worth, there are categories of damages that we do anticipate being considered by the court as part of this process. Medical expenses is an obvious one, and we'll talk in more detail about the impact of those medical expenses either having been incurred at a VA center, VA treatment center, or Medicare or Medicaid as opposed to private insurance. But nevertheless, medical expenses. We've talked to a lot of folks who have been unable to work or had to stop working as a result of the diagnosis or condition caused by the water. And obviously folks who died of premature death while they were still of working age, were not able to meet their full wage earning time. So pain and suffering, emotional damages, loss of quality of life. Many of these diseases and disorders impair function, make life very difficult. Permanent disability, other life-altering health effects, and finally the ultimate damage, death. As on that topic, if you are making a claim on behalf of a deceased loved one or family member, an estate will need to be opened in the state where the decedent lived at the time of their death. So if they were living in Rhode Island at the time of their death, even though the claim will be pursued here in North Carolina, an estate will need to be opened in Rhode Island. Many folks may have had an estate opened, but conducted all the necessary business and closed it. In that event, it will need to be reopened. If the person who was originally appointed as the estate representative is still able, capable, and willing to serve as a state representative, that's a logical and natural choice. If not, then a substitute representative will need to be appointed. Every state's a little different in how they handle that, but there is a process to appoint a successor or subsequent estate representative that typically would look at a list of potential folks to serve, usually family members, and then get everyone in that same category of family members to either renounce or agree to a particular representative if there can be an agreement reached. So that's just more of down the line after you decide to make a claim, some of the process that will need to be completed. Next slide, please. So the question that many of you have been waiting for, will you lose your VA benefits or your spousal VA benefits if you make a Camp Lejeune Justice Act claim? We believe the answer is pretty clearly no. There has been some information to the contrary circulated. I don't know where that's coming from. I don't know why that is out there. The final answer will eventually have to be decided, but it has not been decided yet. The reason that I do not believe your benefits will be lost is because of specific language in the Justice Act itself. Next slide, please, Haley. Thank you. So in the Justice Act itself, and this is getting pretty deep into the sort of the legalese, but Section E2 of the Justice Act provides that any award made to an individual shall be offset by the amount of any disability award, benefit, or payment provided to that individual. The act then goes on to address three specific benefits or payments: VA benefits, Medicare, Medicaid, which obviously are government programs. And so benefits paid under those categories, the act says, will be offset or credited against a recovery under the Camp Lejeune Justice Act. Similar rules have been applied for decades and decades with regard to other personal injury recoveries. Say a standard car accident case where the medical bills were paid by Medicare or Medicaid, let's say Medicaid. When that occurs at the conclusion of that case, whether it be by settlement or verdict payment, however it ends, then Medicaid gets reimbursed and Medicaid continues. Same with Medicare. Medicare is reimbursed and is continued. And so the thought is that something similar would occur here, and that is there would be reimbursement or offset or credit back for the benefits, and then the net would be paid. And so it's hard to imagine that when Congress finally, decades later, tried to right this wrong by allowing claims to be made against the United States government, which is unprecedented in this manner, that the intent of the act was to leave the servicemen or injured party worse than they were had they made a claim under the act. That really wouldn't make a lot of sense. And so, again, nobody knows exactly how this is going to work. This is a brand new piece of law. It has never played out in the court system. There is no track record for exactly how this is going to work. But we believe that it will not end or result in a termination or loss of benefits, but will result in a net greater recovery than not making a claim at all. Next slide, please. Patients. Understandably, folks whose families have been devastated, loved ones have been injured or have died as a result of this are very anxious. There has been years of fight and effort and advocacy, struggles, denied claims, folks struggling to sort of make ends meet to pay bills because of someone being unable to work, and being having to deal with some terrible calamity caused by this water. And then this bill's passed, and the hope is that all of a sudden relief is here and relief is imminent, and it'll all be made okay, or at least better quickly. And unfortunately, I just don't think that's the case. We are urging patience. What I have been telling folks is that I do not think the time between today and an ultimate recovery for an individual will be measured in days. I don't think it'll be measured in weeks. I don't think it'll be measured in months. My best guess is that it'll be measured in years. And for folks, especially with terminal illnesses, who may not see the end of this, that is very difficult to hear. But just looking at kind of how this process is going, the sheer enormity and size of it, the fact that there is no existing framework or structure for these claims to proceed through, and based on how the initial litigation has proceeded, I think it's going to be a long, slow process that's going to require a lot of patience. So I indicated earlier that there's an administrative claim process that must be completed prior to the filing of a lawsuit in the Eastern District of North Carolina. I also described for you how about a decade ago or so, there was a group of folks who filed administrative claims, some of whom filed lawsuits that were dismissed that led to the legislative efforts that got us to today. There are, and just the number's not exactly right, but order of magnitude, 100 to 150 folks who went through the administrative process, had their claims denied prior to the passage of the Justice Act, who have filed lawsuits and that are currently before the federal court under the Justice Act. We are counsel of record in some of those actions. We are working with some other lawyers who have other ones. So far, just to be frank with you, there hasn't been a lot to report that has occurred in those pending actions. The actions were filed with the court system. They were assigned to judges. There are 4 judges in the Eastern District. All 4 of them currently have some of the Justice Act cases. A group from the plaintiff side communicated with the government. The government is defending these claims from what's called Main Justice. The Department of Justice out of Washington, D.C. Is currently managing the defense of these claims. The DOJ, or Department of Justice, worked with the lawyers representing the current plaintiffs to file a joint or collective motion to consolidate, asking that the pending claims be brought together for common management, for common organization. Those motions have been denied by 2 of the 4 judges and are still pending before 2 of the other 4 judges. So as it sits right now, it is very unclear as to what timeline or timetable those cases will take. I will let you know that the government indicated, it's a matter of public record, in the motion to consolidate, that they do intend to file a motion to dismiss all of those lawsuits in an effort to make each of those plaintiffs go back through that 6-month administrative process that they went through one time, and either the time expired or the government denied their claim. And so You can kind of see a pattern, probably one that you have come to become familiar with if you have tried to get benefits related to Camp Lejeune or other issues. Oftentimes there is delay. And we just don't know what the court yet will do with those motions to dismiss, whether or not those plaintiffs will have to go back through that administrative process and come back to the court system after the completion of that or not. So patience, that's what we are encouraging. This is going to be a long, slow process. We've got a couple of additional questions. One by Mr. Quilty. If a veteran has already begun receiving VA disability compensation for a presumptive Lejeune disease, how long will that affect any award, or how will that affect any award through the suit? Similar question to one that I have addressed earlier. The law says that there will be an offset or credit for the existing benefits that will be credited or offset against an award under the Camp Lejeune Justice Act. And so the math won't be this simple, but let's just say that $20 had been received at the time of a Camp Lejeune Justice Act award in VA benefits, and $100 is the Camp Lejeune Justice Award. Then a simplistic way to look at this would be that the government would be responsible for an additional $80 in Camp Lejeune Justice Act benefits. Again, the mechanics of how that'll work, the timing of how that'll work is unknown, but certainly the law contemplates an offset or credit reduction of Camp Lejeune Justice Act compensation for previously paid benefits so that the government's not paying twice. We've got some other questions. I think we've answered that. Ms. Hudson says, if I'm an impacted person, other than hiring a lawyer to file a claim, is there anything else that I can do? So an individual can file their own Form 90 or administrative claim form if they want to try to proceed without a lawyer. Quite frankly, I think that's going to be logistically difficult, but in theory possible. In theory, an individual without a lawyer could file a claim in the federal court system. In fact, I think one of the currently pending ones is what's called pro se or unrepresented. There's a lawyer not involved. But given the complexities of this act, the medicine and the science involved, the level of proof, and just how the federal court functions, I believe it's going to be incredibly difficult to navigate this system. And just to be frank, probably not wise to proceed without a lawyer. So in my mind, the decision is which lawyer you want to hire, which one is best for you, best suited for you, which one are you most comfortable with. Things that you can be doing outside of what your lawyer is doing or while your lawyer is proceeding with the claim and representing you. What can you be doing while you're exercising this patience that I have described? Many of the things on that list we addressed earlier. So creating a list of medical providers, trying to come up with a best estimate of what dates or time span each of those providers provided treatment to you or your loved one. And if possible, trying to locate those records. If you're signed on with us or eventually signed on with us, we're not asking to have those sent to us yet, but collecting them would certainly be prudent. Gathering any VA benefits that you have, information, documentation, correspondence. We mentioned those letters where the VA has acknowledged a link between a particular disorder and Camp Lejeune. And then the third category of information I would say that it would be helpful to gather is anything that you can put your hands on to establish that the claimant had that necessary 30 days or more exposure at Camp Lejeune, whether they be equipment invoices, DD-214, other service records. So gathering information, receipts to show you were there and when you were there. If you were not living on base, then brainstorming, coming up with ways that you were exposed to the water as someone who lived off base. Let's say I lived off base, but I went to a particular building on base. That's where I reported to duty every day. I was there for 90 days in that building. We ate lunch there. We ate lunch at a particular place. We drank the water there. I filled my canteen at XYZ place every day. I drank out of supplied water containers during exercises and dislocation on base, those sorts of things. And then the last category of information I would encourage folks to go ahead and begin working on is documents pertaining to an estate. So opening or reopening an estate in the residence where the decedent was at the time of their death, if in fact death has already occurred. Ultimately, the court system, whatever it might be called in that particular state or jurisdiction, will issue or prepare or provide a document. In North Carolina, they're called letters, but basically a document giving a specific individual legal authority to make a legal claim on behalf of the estate, to speak for the estate. And then finally, once you do hire a lawyer, what I would encourage folks to do, particularly if you or your family member, whoever is making the claim, is very ill. And we are finding quite a bit of this. Unfortunately, many claimants will not live to see the end of this effort. And if you or a loved one fall in that category, keep your lawyer abreast of the health condition, of progress, any material changes. It may be necessary for efforts to be taken to preserve testimony for loved ones who may not live to see the end of this. And so make sure that your lawyer is aware and in the loop if things change and or conditions deteriorate such that you think steps need to be taken to preserve that testimony so that the court and ultimately, if the case is tried, jurors can hear from that individual and how they were impacted by this exposure. I think we've got some other questions. Is there a possible monetary compensation different between joining the lawsuit now versus waiting and joining later as more is known about how it will play out? So a couple of things. One is there is a 2-year window from the passage of the date, passage of the act, and we're a couple of months beyond that already, within which the administrative claim must be filed. Once that administrative claim is filed, your time is told, your place in line is held. But if you wait longer than 2 years to file the administrative claim, then you will be in the same category that folks were before this act was passed, and that is your claim will be time barred. While 2 years sounds like a long time, it does take or can take a bit of process to get those claims forms filed. So I don't encourage anyone waiting until close to that 2-year mark to begin that process. Certainly one could advocate or create a rational argument that I want to kind of wait and see how this plays out a bit. Most lawyers, certainly our firm, are handling these cases on a contingency basis, meaning that there are no legal fees owed if there is no recovery. Most lawyers, including our law firm, are also handling them on the basis of expenses being advanced or paid by the law firm or law firms working on the claim, as opposed to by the individual claimant. And those expenses are not required to be reimbursed unless there is a recovery. So even if you did start the process now, and ultimately your claim was not successful for one reason or another, weren't able to establish a causal link, or for whatever reason the claim does not successfully proceed, the recovery is zero, at least with our law firm, you would not owe anything, such that you wouldn't be worse off for having made the claim, other than the limited time that's necessary and sort of the emotional involvement in answering those questions, sort of reliving the event. And that certainly is part of it. It dredges up feelings. These are emotional issues, but there shouldn't be a dollar cost to you if ultimately your claim is denied or there's no recovery. So in that regard, it does make some sense to go ahead and make a claim soon, or relatively soon, because there isn't a financial risk. There is no reason to do it today or tomorrow or Monday. So certainly reasonable to make a good informed decision, gather information about lawyers, law firms, what their strategy is. Is the law firm gathering a group of cases intending to sort of sit on the sideline and hope to attach to a settlement later? Maybe that's what you want. Or is the law firm or the law firms who are working together, is their intent to work the cases up, to be involved in the medicine and the science and participate in the litigation and to try your case to a jury if that's necessary? That's the category we fall in. That's the way we're approaching the cases. We are not investing money in advertisements, TVs, billboards, Facebook blasts, robocalls. We're investing money in the science and medicine, the experts necessary to prove the cases. Different philosophy, different strategy. Other law firms are doing it differently. You'll need to find the firm and the lawyer you're most comfortable with and the approach that you're most comfortable with. We've got one or two more here. I think we talked about the deadline, 2 years, although I don't recommend waiting. Another question by Mr. Quilty. Could adult children of Camp Lejeune veteran who died of a presumptive like Parkinson's file an estate if their father was single or outlived a spouse? Yes. Ultimately, only one individual can be appointed to represent the estate. The money would be distributed out amongst or between the beneficiaries at the end. One individual would be appointed to represent the estate. Typically, beneficiaries would be of a decedent would be a spouse if they were married at the time of their death, and children. And if there was no spouse at the time of the claimant's death, then that claimant's children. And in some cases, given how long these, how old the exposure was, we have situations where grandchildren are making claims on behalf of their grandfather primarily, because at that time, servicemen were exclusively male. Their grandfather, such that it's one generation even removed. So that answer is yes, Mr. Quilty. Mr. Holman, is there any out-of-pocket cost of filing the claim with Warden Smith? That answer is no at the outset. You're not asked to advance any cost. You would not receive any bills as the litigation goes on. At the conclusion of the litigation, the contingency percentage for the lawyers in time, legal advice, legal efforts, the fees, legal fees, the contingency percentage would be paid, and then the expenses would be deducted at the end if and only if there's a recovery. If there's no recovery, there would be no expenses owed, no attorney's fees owed. One more question. My dad was the one at Camp Lejeune and is now deceased. would my mother and I file separate lawsuits or together? The answer is there would be one lawsuit, and that lawsuit would be filed by whoever the court appoints to represent the estate. And then the proceeds would be divided, perhaps not equally, but divided between your mother and you, and if you have any living siblings, them. But there would be one claim, and that would be filed by the estate of your father, and more specifically by whoever the court appoints to be the representative of the estate. I think, Haley, have I answered all the questions that you see?
Yes, sir. I think you have. I'll go ahead. Oh, someone is raising their hand.
And folks, I can't see you. I can, and so if you're, thankfully Haley can, but if you have a question, want to drop that in the Q&A, I'm happy to try to address that for you before we conclude. While that's coming through, being typed up, if you haven't been to our website, it's www.wardensmith.com. You see the name on the screen, Ward and then and spelled out smith.com. We have an entire portion or landing page dedicated to Camp Lejeune water contamination. The intent there is to provide as much information for folks as possible. And so there are links to these studies I've referenced, the ATSDR, and you can kind of drill through those links and get a tremendous amount of data as well. There's a list of diseases that were found in this presentation and a lot of other information. There is also a spot on our website that it's a black box with the words free consultation. It's typically in the lower right-hand corner of the screen when you go there. And if you click on that, that link, then a questionnaire will pop up where you can enter some information, and then we will respond to you and let you know whether you qualify or not. We also have a dedicated staff member who is fielding questions all day, every day, helping folks walk through the process of signing up if they're interested, letting them know if they qualify, those sorts of things. His name is Mr. Brian Preston. You can call our law firm and chat with him as well. I think there's some information. Okay, that was in the chat.
Lynwood, that question did come through, and the question was, can we please provide the citation to the Camp Lejeune Act?
I can't through the means that I have where I'm sitting at the moment, but if someone wants to send me an email after the presentation, my initials are L as in Lynwood, P as in Paul, E as in Evans at wardensmith.com. So LPE at wardensmith.com. Haley, you might want to drop that in the chat.
Yeah, absolutely. I'll do that right now.
That's my direct email. If you have questions, you can send them to me after today. I'm also happy to reply to an email and provide you a link to the actual text of the act. As I indicated, the Camp Lejeune Justice Act is not standalone. It is part of a larger piece of legislation that's quite long called the PACT Act. Off the top of my head, I think the portion is like 803 or 804 of the PACT Act that specifically addresses Camp Lejeune and these claims. But again, I'll be happy to provide you the specific reference and citation offline if you'll send me an email. Other questions before we close for today? If not, we very much appreciate All right, I think Ms. Hudson helped us out here with I think that's the Senate version of the Act 3373 as there in the Q&A session. You can probably type that in Google and get it to pull up. I've not tried that, but I can get you a copy if you want a full copy of the Act, whoever that question came from. Any other questions? If not, then we very much appreciate your time and your attention and your interest. It would be our honor to help you, to represent you, your family, your loved one in this process. And we're available for questions should additional questions arise as you move forward, either in your claim process or move forward in your decision-making process about which lawyer, which law firm you feel most comfortable representing you in this claim. So with that, I'll wrap up.
Thanks so much, Lynwood. And like you said, we will be emailing out a copy in PDF form of these slides. We have also recorded this webinar, and I will include a link via email to watch the webinar through our YouTube channel. We encourage you to share this information with other family members and friends as well that may qualify for these claims. We appreciate the time that you've given us this afternoon. Thank you again. That's going to conclude this webinar.
Thanks, folks. Take care.